All right. Good afternoon, everyone, and welcome to the Ramsey County Law Library Zoom CLE event for this month. My name is Shannon Stoneking, the Ramsey County Law Library Director. Our CLE presentation today is entitled Picking the Low-Hanging Fruit, five favorite ideas to avoiding ethical complaints, as you can see on the screen there, presented today by Amanda Siefman and Karin C Ciano. Ciano? Yes. Okay. From the Office of Lawyer Professional Responsibility. And I am very happy that they've agreed to share their knowledge and expertise on this topic with us. Looking ahead to next month's CLE in September, the program will be Reimagining Justice for Youth Initiative on Juvenile Cases. And that will be presented by Kevin Fleming from the Ramsey County Attorney General's Office, or Ramsey County Attorney's Office, sorry. I will send out notification about the CLE to the email list at the end of this month. You can learn about any of our future CLEs that will be posted on the Ramsey County Law Library website, as well as the Ramsey County Bar Association Barristers website. You can also reach out directly to the Law Library if you have any questions or suggestions about any future programs. Few housekeeping details for today. This event will be held as a live presentation, but after I will be reviewing this recording to see if it can be submitted and available as an on-demand program. This will have a different number, a CLE approval number assigned to it. And we are working out some kinks on the on-demand programming. So if you are trying to access it or know of people that are, please have them reach out to the law library for any assistance. Today's program is still pending approval for ethics credit, but that event code number for today is 534181. And this number will be posted in the chat section after the speaker's introductions. Some quick other guidelines. Questions are always welcome and appreciated. If you have any, please type those into the Q&A section, but will also be monitoring the chat section. And now I will be introducing today's speakers. Amanda Siefman serves as the Assistant Director at the Office of Lawyers Professional Responsibility. Prior to moving to Minnesota in 2025, she previously worked as a supervising staff attorney in the 20th Judicial Circuit of Florida for 11 years. During this time, she assisted the circuit's judges with a variety of cases from local governments, disputes, and civil litigation to post-conviction and effective assistance of counsel claims and death penalty prosecutions. And Karin Ciano is a senior assistant director at the Office of Lawyer Professional Responsibility. Before joining OLPR in 2021, Karin litigated civil rights and employment discrimination cases at her own firm, as well as contested probates of counsel with Mason and Helmers. She also worked as a freelance lawyer, helping other lawyers with writing and litigation projects. In addition to teaching CLE sessions on ethics and writing, Karin has taught classes at the University of St. Thomas Law School, Mitchell Hamlin School of Law, and University of Minnesota Law School, and also New York University School of Law. An enthusiastic transplant to Minnesota, Karin believes in the power of solo and small firms to close the justice gap. Karin is OLPR's liaison to the 4th District Ethics Committee and a member of the Rotary Club of St. Paul. And thank you all for your attention, and it is now my pleasure to hand things over to our speakers.
Thank you, Shannon. Hello, everybody. Let me just begin by saying, obviously, I'm Karin, and I am a huge fan of the law libraries of the state. I used them extensively while I was in private practice, and I consider them to be a tremendous resource. So I'm delighted to have the opportunity to present here today from my perch with OLPR. And Amanda and I are going to talk about, we were coming up with ideas for this presentation, and we kind of were thinking, in law school, people love to teach the edge cases, the really obscure, weird, stumper kind of scenarios, when in fact, what most of us need is the low-hanging fruit, the base cases that we see every day, every week. And so Amanda and I kind of put our heads together and we were thinking about things that come up a lot. And are there ways that lawyers can avoid complaints and avoid violations? So that's kind of the theme here. And we do, just to echo Shannon, we welcome your questions You can put them in the chat. You can give them to Shannon. She'll make sure we get them. You can also reach out to us after the presentation, and you can see we've got our emails there on the first slide. So we are at your service. All right, and with that, Amanda, let's take it away. Wait, you're muted. This is how we know we're on Zoom.
There we go. Exactly.
Nailed it.
Good afternoon, everyone. It's now afternoon, so good afternoon. So to get started today, we're going to kind of zoom way out and think about what most ethical evaluations that come into our office are caused by. So we've got our little list here of quick little points to go over. One of the big ones is poor office procedures. Whose job is it to open the mail? Whose job is it to return client phone calls? How often are clients given updates? Office procedures are in place to handle a lot of your everyday activities at the firm. And if those procedures are poor or have issues, it can lead to ethical situations. Another thing that many people might find themselves in, especially if you are in a practice area that relies on volume and flat fee agreements, is taking on too many cases. It's easy for tasks to fall by the wayside if you're juggling a lot at once. And on the flip side, taking on cases in areas of the law where you have little or no experience. Your neighbor says, "Can you help me send the demand letter?" A relative asks you a question. Um, Basic steps in those kind of situations are going to take more brain power to get through if you're unfamiliar with them, and then that's where details can be missed and important steps can be missed. This is a really big one, failing to establish realistic expectations about the case with the client. Does the client think their case is really strong when it really isn't? Do they have a different idea about how the case is going to go than you do? If you discover during discovery that maybe the case isn't as great as you thought it was, have you told the client that, or does the client continue on with a different expectation about how the case is going to go? And then finally, not getting good, timely ethics advice. This is a big thing for Karin. I know in particular that even if you're a solo practitioner, there are resources available to you to try to help you figure out these situations out. You don't have to go it alone. So when you're in doubt, you can reach out either to a colleague or to the OLPR looking for advice about how to handle a certain situation.
All right, and that is completely correct. So summertime. I hope everybody is getting at least a little bit of the August lull. It hasn't been much of a lull in my seat, but I realize, people sometimes have a little bit more time. So it's the perfect moment to harvest the low-hanging fruit. And we're going to focus on 5 areas, kind of building on what Amanda just said. Fee agreements and fee handling, because these are things where the rules are complicated but relatively clear. And this is a good time to go through your fee agreements. Thinking about how to overcome the temptation to procrastinate, how to manage those client expectations and communicate, even if what you need to communicate is goodbye. Making sure that if you're using tech, you're understanding it and, just understanding what your obligations are with regard to the tech. And finally, getting ethics advice, about which more later. I will add this disclaimer, which I put in all of my CLEs, which is that I cannot keep myself from simplifying and paraphrasing the rules. The full text is available on our website from the reviser, Lexis, Westlaw. You might have a book like this. You might have, other books, but, when in doubt, read the rule. We'll be paraphrasing. So first up, fee agreements. I don't know whether you knew this, and I have to confess, it didn't really occur to me until I started teaching professional responsibility. But Minnesota's rules of professional conduct on a lot of things are not always on all fours with the model rules, which is what you learn in law school. And in particular, Our fee-related rules are very, very different, like strikingly different. They're more detailed, they ask for more specific stuff, and there are specific things that you cannot do. So if the last time you were thinking about ethics and fees was in law school, you're in for a treat. I'm going to suggest that this would be a great time to take a look at the two rules that govern fees in Minnesota, Rule 1.5 and Rule 1.15.
All right.
Amanda?
So, here are the big bullet points. Um, Fees must always be, under Rule 1.5, reasonable and communicated to the client promptly, preferably in writing. Now, we're going to get into the details on that, and when sometimes you do need a written fee agreement, usually that is in a case where you have special fees. So, flat fee agreements, availability fees, contingent fee agreements, fee splitting. That's going to be a situation where the rules require a written agreement. But it is not technically required in every case. You may ask yourself, well, if you get into trouble sometimes with fee agreements, why wouldn't you want it in writing? Well, um, a lot of what is contained in a fee agreement is here's what's going to happen if you don't pay me. I'm going to sue you back. That's not necessarily the best way to get started on the right foot with a client. And if you tell the client, this is my rate, I'll take your case if you like, they say yes, and they never pay you a retainer fee or anything like that. You're just send them bills. They pay bills as they come in. That's perfectly okay. You don't need it at in writing. So that's why the rule doesn't require the fee agreement to be in writing. I think there's a lot of attorneys who don't necessarily need to do that and don't do that, and it's fine. But the thing about having the fee agreement in writing is that then the basis for the rate of fees was communicated to the client. So it's something to keep in mind. It may be a good idea to have fee agreements in writing, even if it's not necessarily required.
It will shock you to hear
Yes,
that sometimes clients and lawyers who come to our office with complaints disagree about what the agreement on fees was.
right.
So that writing is good evidence.
Yes, it is. So that's Rule 1.5. 1.5 is how you're charging fees, how you're communicating the fees to the client. Then there's Rule 1.15, which is once you have taken client money, what do you do with that money? That's going to be your trust account situation. Our office generally doesn't get involved in fee disputes, but trust account issues is that's one thing that's going to get our attention very quickly. And then in terms of Rule 1.5, if it appears that the lawyer is charging the client for work that hasn't been done, or didn't wasn't upfront with the client about how fees would be calculated, or how often they would need to pay, or is not being truthful with us. That's always going to get you in trouble with us when it comes to fees. That's when we're going to start to see some more issues with complaints that come into the office. Okay, so these are the no-nos. Don't do this. Fees can never be described as non-refundable, ever. That should never be in your fee agreements at any time, or earned upon receipt. If you take client money, but you haven't done any work yet, you have not earned the money. That is a situation, and we're going to get into this a little bit more, but that is a situation where it usually needs to go into a trust account because you have not done any legal services yet, so you haven't earned the money yet. If the representation ends before an advance fee is earned, the unearned portion must be refunded. So it's okay for the written fee agreement to say that the advance fee is the lawyer's property subject to refund, but it's either still the client's property and therefore needs to go into a trust account, or um, it is the lawyer's property subject to a refund if the representation terminates. So, um, branching off from that, when can a fee be placed directly into a non-trust account? If it's not an advance payment, so we went over that a few minutes ago, you tell your first consultation with the client, this is my rate. I'll be sending you an invoice every month. They say, okay. So every time they pay you, they're just paying an invoice. They're just paying you for work that you've already done. That's fine. You've already earned that money. That does not have to go into a trust account. Or if it's an advance payment or a flat fee or an availability fee that complies with rules 1.5b. So that rule will say if it's not going to go into a trust account, it needs to, that has to be explicitly written in the fee agreement, which I think is possibly, I might be getting a little ahead of myself. It might be on the next slide. Yes, so Rule 1.5b1 covers flat fees. The big ideas are that the lawyer may charge a flat fee for specified legal services. That's fine. If agreed to in advance in a written fee agreement signed by the client, the flat fee is a lawyer's property subject to refund. And then the written fee agreement needs to notify the client of certain things. The nature and scope of the services to be provided, the total amount of fee and payment terms, the fact that the fee will not be held in a trust account until earned. This needs to be explicitly stated in the written fee agreement. That the client has a right to terminate the client-lawyer relationship. And then if the relationship is terminated and the agreed upon legal services are not provided, the client is entitled to a refund of all or a portion of the fee. Portion being, if you do $500 of work on the case before it's terminated, then you probably can keep $500 worth of the advance, and that's fine. And all 5 of these things need to be in the agreement.
A
Sorry.
couple of pro tips.
Yeah.
Number one, lawyers love to edit and massage the text and make it their own. With this, just don't. Just, see how it's written in the rule, put it in there. We sometimes run into fee agreements that say the client may be entitled to a refund, and that's a no-no. So you want to make it as close to this text as you possibly can so that all of the rule is complied with. The other little tidbit is that sometimes when a flat fee agreement is terminated, a lawyer will want to go back and they'll say, well, shoot, look at all the time I spent on this matter. If I was billing hourly, you would have owed me twice as much. So I'm not going to give you back anything. Ha ha. And that too is ill-advised because if you haven't completed the scope of work that's in that flat fee, some refund is going to be owed as far as
Right.
our office is concerned.
Right. All right, so let's
So
move on. Oh, I'm sorry.
we've got a hypothetical coming up.
Yes.
Get ready.
Moving on to our first hypo.
Here it
All right.
is.
So Leon retained Aaliyah after he was arrested for felony domestic assault. It initially appeared like the case might be resolved early with a plea. Aaliyah told Leon that she required a $2,000 retainer paid in advance to represent him. Leon paid the $2,000 retainer fee, but there was no written fee agreement. Aaliyah deposited the fee into her operating/business account rather than her trust account. The prosecutor brings some additional charges, and so hopes of an early plea are dashed. For the next 18 months, Aaliyah performed legal services on Leon's case, but did not send to him any billing statements or otherwise account for the $2,000 in retainer funds. 18 months later, when the case is headed for trial, the lawyer tells the client that her $2,000 retainer funds had long ago been exhausted by legal fees. She provides an invoice for $7,000 in additional legal fees and also demands an additional retainer of $10,000 to represent him through trial. Okay, so that's a situation. First question, did Aaliyah need Leon to sign a written fee agreement? Let everybody think about it for a second. So written fee agreement's not required, but without one, this advance payment needed to go into trust. So the fact that it was deposited into her operating/business account instead of her trust account, that's a problem. That is not good. Was she obligated to send invoices earlier than 10 months into the representation? Well, once again, obligated, not necessarily in every case. But this is a situation where this $2,000 should have gone into a trust account. And when you deposit an advance payment like this into a trust account, when you withdraw the money from the trust account, that's part of the trust account management. So waiting 10 months before sending Leon a bill, um, probably, that's probably not how long it took her to earn that $2,000. And in fact, we know from this hypo it wasn't because he had actually racked up an extra $7,000 in legal fees since that time. And he was never notified of that. That's a situation where the client, look at it from the client's perspective, that's going to be, a major sticker shock situation. And this is probably, not only is the client going to be very mad at the attorney here, but this is probably going to turn into a fee dispute. And then it's a much bigger issue. Um, Karin, you want to add anything to the invoice
Well,
point?
this is something I hadn't full I recall, from practice that this is a situation where you think you're doing the client a favor by not billing them. But sometimes it's not really a favor because the client needs to know the rate at which the attorney fees are accruing. That is a material piece of information in how they make decisions about their case. And so sometimes not communicating that information to the client can violate Rule 1.4b, which is one of the communications rules. It's the lawyer's duty to explain matters to the extent necessary to allow the client to make informed decisions about the representation. So, if you don't make it your practice to bill regularly and keep the client informed, even if they're not paying you about the rate at which fees are accruing, you may be depriving the client of important information and opening yourself up to a potential dispute later. And also, you might not get paid.
Right.
Always a
And
problem.
always a problem. And then this final question here, can she ask for an additional retainer? Yes, she can. Whether Leon is going to pay it in this situation is an entirely different matter, but it's fairly common, I think, for, additional retainers to be required if a case makes it to trial. Um, but again, if that ends up being an advance payment for trial, that's another situation where the trial hasn't happened yet. It really needs to be going into a trust account instead of the operating business account.
If you get it before you earn it, you're a bank, and you
Yes.
need to put it in the trust account. So low-hanging fruit number one, on your summer break, go through your fee agreement and check to be sure that it is doing all the things that Rule 1.5 and 1.15 ask you to do. In particular, if that it doesn't say non-refundable, that it does, if you're taking any kind of a special fee, comply with the requirements of Rule 1.5b or c for those fees, and that that you have a process in place to be sure that any money you get before you earn it is placed into your trust account. Have you seen a non-refundable fee agreement, Amanda?
Yes, I have. Even though I think it has been the rule for at least 10 years that that's not allowed. That
Since
language is not allowed.
2011. It's been a
2011.
long time.
Even I
And
have seen that. Yeah.
so people, this is where it's like
Yeah.
just like hunt through your fee agreements and be sure that that language is out, and you will save you and your clients a lot of trouble. All right, moving along to the next topic, we have procrastination, which is a theme of life and also a theme of law practice. So Amanda, tell us about the obligation of diligence.
Okay, so under Rule 1.3, um, the rule is actually very short. It says a lawyer shall act with reasonable diligence and promptness in representing the client. Rule 1 tells us the definition of reasonable denotes the conduct of a reasonably prudent and competent lawyer. Although this rule is very short and deceptively simple, we can run into a lot of different permutations with this rule. It is highly fact specific. It depends very much on what happened, what the client or the complainant is alleging happened, what the lawyer tells us happened. It can be confused with Rule 1.1, which addresses competence. It's also a very short rule, and we'll get into competence a little bit more later. But Rule 1.1 says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So Rule 1.3 is about diligence and promptness. Rule 1.1 is about thoroughness and preparation. A little bit of overlap there with that.
I tend to think of Rule 1.1 is about what I know, and about 1.3 as what I'm doing. Like
Right.
I know what I need to do, I'm just not doing it. And that's where low-hanging fruit number two comes in. I sometimes think that thinking about what are the tasks in my queue, and let's be honest here, we probably all have a list of tasks. Are there ones that I keep avoiding day after day, week after week? Am I stuck or blocked on getting something done? Having a good policy, having a good practice in place to deal with that is essential. I didn't invent this saying, but I love it that habits always beat willpower. So, taking a moment, maybe at the end of every week, or at some point when you have 15 minutes of clarity, just to spot, okay, what are the things that I'm just not getting to? Can I talk to somebody, whether it's a mentor, a friend? Lawyers Concerned for Lawyers has a solo and small group. You can call us for an advisory opinion on an ethics question. Sometimes talking through whatever the issue is with someone can get you unstuck. Controlling your workload. I mean, especially again, if you're a solo small firm, it's on you to be sure that you're not procrastinating. It's nobody else's job but yours. But you do have the power to set your office practices, to say no early and often, and to put the structures into place that will support you. Most of all, um, diligence requires honesty, first with yourself and then with other people. What we sometimes see is the lawyer who is the dishonest procrastinator, and it's from a human standpoint, very understandable. We don't always like to admit to ourselves when we're in the shame spiral of, the fact that we're dropping balls and letting things go. And so our minds start to make up excuses and reasons that are not necessarily correct. And then, the problem is that once you start saying that to yourself, you start saying it to other people. And when you start saying things to other people, clients, courts, opposing counsel, about why you are late or what you are doing that are not true, that can suddenly spiral into problems of being dishonest or misleading. And that's much more serious misconduct than just not being diligent. So, developing the habit of identifying where you're stuck, being honest with yourself about that fact, and having strategies to kind of break the logjam is important. And I would just encourage everybody, build that support network to help you through it. Which brings us to client management and withdrawal. We have another hypothetical coming up. So, Amanda, take it away.
All right. Hypo 2. Marco retained Annette to represent him in a Social Security disability petition. Annette worked with him to gather the necessary medical documents for his petition/application and submitted it for consideration. The expected timeline for response in these kinds of matters is 6 to 8 months. 2 months after the petition was submitted, Marco starts emailing and calling Annette every day, asking for an update. At first, she responds to each request with assurances that they will be informed when a decision has been made and information about the expected timeline. But eventually, she stops responding. At the 8th month mark, no decision has been rendered, so Annette goes into the online system to check the file. She sees that a denial, was made approximately 4 months after the application was submitted. Therefore, they are well past the applicable appeal period. Reluctant to give Marco the bad news, she immediately reaches out to SSA to see whether an exception can be made. So give everyone a second to think about that. And my first question is, what happened here? How did this happen?
Put
Right?
on your investigator hats. Like,
Yeah.
we're just armchair speculating. What do you think happened?
Yeah. So, I'm sure everyone reading this has had a client who is calling way more often than they need to ask for updates that you do not have anything to give them on because nothing has happened since their last call. I'm sure we are all very sympathetic to this situation here in the early part of this hypo where he wants to know, it's only been 2 months. She told him expect something in 6 months, yet he's calling her every day. Eventually, she stops responding to his requests for updates. Um, then we find out 8 months later, well past, now we were expecting to have heard from SSA by now, haven't heard from them. Go in the file and we see that there has been a decision much earlier than we were expecting, 4 months later instead of 6 months, and it was a denial. So how did that happen? How did Annette miss that? So the first thing I see when I look at this is that something went wrong here with office procedures. Either it came in the mail and it got buried underneath a bunch of other stuff. Somebody opened the mail and didn't tell Annette that this had been received. Or if it's electronic, you signed up for e-service and you didn't open the email. Something happened here. Somebody who was supposed to do something didn't do it, or something that was supposed to happen didn't happen. So that's a major office procedures issue. Um,
And
so
you need to
then,
put your forensic hat on to kind of
yeah,
figure out like whose error was it and where did it happen?
right. So what ethics rules are implicated by this scenario? Well, um, there is Rule 1.4, which controls client communication. We're going to get into that on the next slide, but Annette is under Rule 1.4, you are obligated to give the client status updates. So, early on when he's calling and she basically does not have an update to give, that is not when the affirmative duty to give an update kicks in. But then we get to this point where she checks the file. 8 months later, she finds a denial. And reluctant to give Marco the bad news, she reaches out to SSA. Karin, what do we think about that? Was that impliedly authorized by the representation, or is that a problem?
Well, it could be both.
Yeah,
My first thought is that, you know, the bad news never gets better when you sit on it, and talking to your client is usually the first step. But I can understand the desire to reach out to SSA to see if there's a fix to the problem before you talk to your client. And so if you're, getting information and you're talking to the tribunal, it's probably, it's not like you're revealing anything that they wouldn't already know. But the temptation can sometimes be then for the lawyer to not tell the client what actually happened. And I would encourage everybody to resist that temptation. Remember that a lawyer has to abide by clients' decisions regarding representation and consult with them about how to achieve their objectives. And so if the client doesn't know what really happened, again, the client can't make an informed decision. And so ultimately, it's going to be the client's decision whether or not to appeal. And so the client's going to need to be informed. Make sense?
yes.
More or less. Okay.
Or yeah.
So ethics rules that are implicated, Rule 1.4 has a bunch of different flavors. And I admit that when I was in practice, I didn't really distinguish too much between them. One thing I have noticed now that I'm on this side of the fence is that the two that we see the most often are 1.4A3 and 1.4A4. 3 involves keeping the client reasonably informed about the status of a matter, and 4 involves promptly complying with reasonable requests for information. 1.4B, I was talking about before, also that duty to explain is probably, number 3, like a lawyer will fail to explain. We typically do not get complaints that say, my lawyer told me too much. my lawyer explained too much, too well, too often. It's always the opposite. I called, I emailed, I texted, I couldn't hear, never knew when they were going to call me back. I never got answers to my questions. I never knew what was happening. So these are the things that you need to be thinking about as you manage client expectations. When it comes to 1.4A3, your obligation to give a client updates assumes that something has happened in the case, kind of like Amanda was describing. A decision was made, you didn't know about it, so you didn't say anything about it. But once you do know about it, you need to provide that information. You also should have procedures in place so that you get informed in the reasonable course. They may not succeed 100% of the time, but they shouldn't fail often. What's the plan, particularly important for the summer, if something happens on a case while I'm out of the office? Our director, Susan Humiston, has an article on our website that basically says, yes, you can take a vacation. And the idea is that you can have a plan in place that someone is checking the mail or the emails, that someone is responding to client inquiries, so that while you are out, you've got help. And that's important because sometimes, if a decision happens and there's a short time frame, you want to be sure the client isn't prejudiced. When it comes to responding to requests for information, that's 1.4A4, thinking about what happens when a client reaches out to you. There's so many different channels now where a client can reach out in so many different ways. Where are you available? What happens to those communications? Who responds? Are they documented? If you can't provide a substantive answer, are they at least acknowledged? Is there some estimate of when you might be able to give them an answer? And thinking about, how do I, in this era when there's so much instantaneous communication, how do I make sure that the client knows I may not be able to respond to literally every text you send? Um, if we had a poll, I'd run it now in the chat and be like, okay, so how many of you have had a client who's in touch like 5 or more times a day? I bet that number is not zero. And so,
Way above
figuring out
zero.
way above zero. So, I mean, figuring out how to handle that situation and help the client understand, communicate clearly. I will respond, unless it's an emergency, once a day, twice a day, once a week, whatever is happening. Because it has to be, we recognize like sometimes the requests can get unreasonable. When it comes to communicating with non-clients, that's an expectation also worth setting with your clients, because the non-clients will sometimes complain to us about, hey, the lawyer isn't talking to me. And, that's something we need to look at, although if there's no attorney-client relationship, that can kind of, forestall it going any further. But sometimes it's not as clear as that. So if you're communicating with someone on a client's behalf, being clear about what they can expect is also important. And last but not least, the difficult conversations. Sometimes when you look at a file, you just realize that there is nothing more you can do. I feel like sometimes, lawyers hesitate to update clients when their opinion of a case changes. And so the client is kind of anchored on the idea, at the beginning, you're like, oh yeah, this sounds like a really strong case, like Amanda was saying. And then the discovery comes in and you realize, well, maybe not so much. Always thinking of it from the client's perspective and also thinking about, can I do any more good here? There will be times when you have to or want to say, you know what? I need to withdraw from this representation. It's a hard conversation to have, but what we see is people getting in trouble doing it too late, typically. Not too soon, but too late. So when you do it, this is one of the things people call for advisory opinions a lot, and we can talk you through the specifics. But you will have obligations if you're in front of a tribunal to follow their rules, and you'll always have an obligation to take steps reasonably practicable to protect client interests, such as returning money and returning a file. So, my low-hanging fruit for client management, sit down, think of your client list, and think about what your next communication with each person should be. It might be resetting their expectations about your communications or about your opinion of the case. It might be just kind of holding their hand and reassuring them that, yep, it's taken a long time, but I'm still here. We're going to get through this. It might be, you know what? Let's talk more because I'm not sure that this representation is still working. But the important thing is to be proactive in making those communications and set up systems in handling your incoming communications and outgoing communications so that it will be easier to get in the habit of communicating early, often, and accurately. Which brings us to dun dun dun.
Know thy tech.
Know thy tech. Tech is everywhere, and Amanda's going to talk to us about tech competence.
Yes. So this brings us back to Rule 1.1, which we mentioned earlier. Just to go over that again, Rule 1.1, another very short rule, says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Sometimes when we run into ethical violations under this rule, people might take it a little bit more personal than it really is. Oh, you're saying I'm not competent? What? No, we're saying that um, part of providing competent representation to the client includes thoroughness and preparation, legal knowledge and skill. Goes back to our first slide where we said one of the ways that a lot of ethical violations happen is from people taking on cases they don't really have a whole lot of experience in, and then stumbling over maybe some of the basic steps that they would have been able to get through much faster, much smoother if they had been more familiar with it.
Yeah, you got to resist the temptation
Yeah,
sometimes to take cases for friends that are outside of your comfort zone.
right.
I think one refrain that I have heard repeatedly from folks who are experienced in a particular practice area is that it's always easy to tell the people who are new, because they just, they're not quite ready to do things in the way that everybody else does. And it can be, at worst, I mean, at best, distracting, and at worst, slow things down and make things more difficult than they need to. So, what about tech?
So, comment 8 to Rule 1.1 gets into this. Comment 8 says to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So that we've added that underline there. And that is part of what we're going to get into today. Yes, this is the obligatory section in the CLE about AI. That is what we're about to get into.
Here it
But
comes.
here it is.
And for Amanda is a youngster
Yes.
relative to me. I'm an old fart, and old farts like me will remember how each of the technologies on this slide rolled out into law practice over the past 30 or so years. And each time people are like, "Oh my God. Oh my God, can I do that? Is it ethical? Is it safe? Is it confidential?" The questions are often very similar. And then gradually, as we get more used to how things work, what started out as being very exotic and expensive and unusual becomes commonplace. And suddenly everyone is wondering, oh, well, you're not using that. And so you need to be mindful that the goalposts move when it comes to tech.
So, AI is a hot topic everywhere right now, in every industry, in every profession. We hear all the time about how this is going to revolutionize so much of the work we do and the lives we live, and it's no less true for the legal practice. It is, if you remember that list we were just on, that is the only thing on that list that is new since I became an attorney. And there is no single definition of what we even mean when we're talking about AI. It can be anything from tech-assisted doc review to analytics to asking for document summary to generative models like, please write a motion for me requesting a emergency continuance. All of those things, we all talk about all of those as AI, and yet we're not always talking about the same kind of service each time we're talking about that. Um, a great thing if you want more information about this is ABA Formal Opinion 512. It released, I think it was last year. It's about 15 pages long, and it gets into stuff like, how AI implicates duties like competent representation, protecting client info, communicating with clients, supervision of employees, because you are responsible for the office procedures that your employees follow. Candor to the tribunal. We've all heard the stories of people using ChatGPT to write briefs, and the AI makes up citations that don't exist, and then it turns into this big ethical issue. And then, you know, and then fees, like billing clients for your use of AI. How is it going to change the fees in certain cases and things like that? Another issue is that, um, there are many AI models that are open to the public. So your clients are probably using AI to do their own things, and they may expect you to use it, even if you don't use it. Um, so that goes back to client expectations. And just as I'm sure everyone has a client who is calling 5 times a day, I'm sure that there's plenty of people watching this right now who have also had a client come to you with something that they researched on AI, and they think that that's the direction that you should go in the case.
Yeah, the law
So,
firm of Google, Reddit, and
right,
ChatGPT
exactly.
has some great information for you.
Yeah,
And by the way, don't charge me for it because I'm giving it to you for free.
right.
Uh, so we we hear you. The important thing to remember is that it's on you to understand what AI does and doesn't do. And you don't have to understand everything. What you have to understand is what you yourself are using. So you read the fine print and then you decide whether it's appropriate to use for a particular purpose. And I know, I'm trying to think, oh yeah. So the thing I sometimes have to remind myself is that there is no tech exception to the rules of professional conduct. It's tempting when a new technology rolls out to be like, oh my gosh, do the rules actually apply to this? Not just for rules of professional conduct, but it's rules of civil procedure. Like, oh my gosh, what do we do? There is no tech exception. So it's on you to know what your obligations are and be sure that your use of tech does not violate those obligations. That's tech competence. We got a new hypothetical.
All right, new hypo number 3. Norm is representing a client in a real estate litigation matter and researching a response to the opposing party's summary judgment motion. He is pressed for time and coming up short finding any solid legal arguments to oppose summary judgment. So he puts prompts for the core legal issue into ChatGPT, and several cases turn up with parentheticals that support his client's position. He throws the cites into his brief and files it with the court/serves it on the other party. The other party's lawyer notes in the reply brief that she cannot find the cited cases and suspects that Norm used AI or otherwise fabricated the citations. Uh-oh. Norm's
This
got
never
himself into a
happens.
problem. Yeah.
Yep.
So is this a 1.1 issue? Is this a competency issue? So now remember, competency is thoroughness, right? So what should Norm have done here? He should have double checked those citations, right? That is really what he should have done. And
Just
it
like
looks
your
like he
legal
didn't do
writing
that.
professor said,
Yes.
if you cite it, you should read it. You
Yes.
are going to, it will be assumed that you know what it is you're talking about, and if it turns out you don't, that's on you.
Right. How about a 3.3, which is candor to the tribunal, or 8.4C, which is the catch-all dishonest conduct rule? What do you think, Karin? Do we have some issues there with 3.3 or 8.4?
Yes,
Yeah,
3.3A1 prevents a knowing, a statement of like false statement of material fact or law, but it also imposes an obligation on the speaker, that's us, the lawyers, to correct when we learn something is wrong.
right.
And so, you know, we all make mistakes, but oftentimes it's how we respond once we realize it that makes the difference.
Which gets
Um,
us into this next question. Does it change depending on Norm's actions after the reply brief is filed? Well, he's probably already in trouble to some degree for this happening in the first place. But if I were Norm, if I want to do damage control here, you absolutely need to send a letter or do something, acknowledging that, I filed something that has errors in it. This is what happened. And if you need to start addressing it early, do not wait until the hearing on the summary judgment motion and show up to court. And the first thing the judge is going to ask is, what are these cases that you cited in your brief that I couldn't find? You definitely don't want to do that. So, but if you come into this situation, you have a duty to correct it. You need to do it immediately.
And I concur.
Yeah,
Sooner is always better when you're dealing with correcting something in front of a tribunal.
right. And what about 3.1 meritorious claims? Does it change if it's a well-settled legal issue? We might need a little bit more information for this particular hypo, but it might be an issue if you're researching something and you're not coming up with anything solid to support your argument. Perhaps this is not a meritorious claim. That may be a red flag. Not always, especially if it's a fact-specific situation or if it's an area of law that's new, maybe underdeveloped, just because you can't find anything that necessarily supports your position, it doesn't mean it's lacks merit. But most of the time, we're lawyers, we're not dealing with novel issues, we're dealing with things that are fairly settled. And if you can't find support for your position, it may be a sign that it is not a meritorious claim and you may be running afoul of 3.1. So here's the thing with generative AI. So generative AI is stuff like ChatGPT. You give it a prompt and it spits out, it writes something for you. The thing about generative AI is that it's not programmed to say, I don't know. I don't have an answer for what you're asking. Instead, it will model a result based on the information that it has. It is programmed to give you a response. So, I used to work as a career law clerk. I had employees working under me, and a few years ago, when this AI stuff started coming out, our policy was to our employees, don't even use this because it just isn't reliable. You have to double check everything it does anyway. Just write it yourself because then that's going to make sure that you've done the work yourself, you've read the cases yourself. That probably, if it hasn't already changed, it probably will change. This stuff probably will continue to get better and better. It's hard to say exactly. Um, but, I remember trying to use it initially when it first came out, and it just didn't know how to tell me that it couldn't find what I had asked it to find. It didn't know how to tell me, actually, that's not the law. This is the law. It was programmed to give me a response. The solution here is to double check. Yes, so lawyers have been sanctioned. We see it in the news. If not the bar news, then the actual news for laypersons as well. Um, Lawyers being sanctioned and disciplined for submitting briefs that can include hallucinated citations. Hallucination is the term for when the AI just makes something up.
Lies.
Lies, basically. And remember, if you're putting it in front of the court, you have to remember Rule 3.3, which is candor to the tribunal.
But wait, there's more. Um, AI may use confidential data, will use confidential data, and the algorithms, they train themselves on what we put into AI to work. So whenever you're using any tech, you need to read the terms of service. You need to understand what it is you are giving them in exchange for what they are giving you. It may not be money, although if you are paying money, you might be giving them less. And particularly when you want to preserve client confidentiality, you have to be very cautious about giving confidential information regarding a representation to an AI to use. And that's a scenario where, it might be we will get to a point kind of like with cloud computing, email, other things. You can disclose to the client, I am doing this, and is that okay with you? We're not probably quite there yet, but as it becomes more normal, more reliable, it will, probably be a thing that we use every day. But again, you need to know what it is that the product you are using does and doesn't do. You need to take whatever steps are necessary in your, setup and whether you buy the pro version or the free version, that kind of thing, to be sure that the information is protected. And your obligation to protect client confidentiality does not go out the window just because you're using AI. The confidentiality obligation under the rules is very, very broad. Not knowingly reveal information relating to the representation of a client. And only if there's an exception in 1.6b can you avoid, do you have a reason to disclose it? So far, there's no AI exception. Also to remember, just because information about a client might be in the public record doesn't always mean you get to discuss it, because it can be inferred that what you are talking about, you learned from the representation. So, you need to be sure if you're putting information out that it is within an exception in 1.6b. That can include the client's informed consent, and you need to protect against unauthorized access or inadvertent disclosure, which is another reason to look at the terms of service. So the solution here is to share carefully, use what you understand, pick the options that protect your confidential information and that otherwise meet your obligations under the rules. Let your clients know. If you have clients who really like the benefits of AI, you may need to use it, but they need to know what you're sharing and when and how and so forth. And then always share the minimum necessary to be sure that you're not having inadvertent disclosure or unauthorized access. Last but not least, ethics problems happen on bad days at the office, when somebody is making your life difficult, when you discover something awkward, when the unexpected happens. And when that happens, you have to think about who you're going to call. There may be somebody at your firm. There are many wonderful lawyers who do disciplinary defense and related work. You might have an ethics buddy in your firm or outside that you can consult with. LCL, as I mentioned, has got a solo and small group that has a lot of people in it. And for ethics questions, there's also us, the advisory opinion line. And I recommend it. One of us is on the desk every day, and we do our best to call people back the same day. We will provide a free verbal opinion on, specific facts to a specific question that you give us. We'll take a little bit of notes so that we remember. It's confidential. No one can have that except you. And our goal here is to try to help you out before you make a decision that might have ethical implications. So 651-296-3952, give us a call.
All right. It looks like we're a bit close to our end time. Do we want to take questions now?
I would be
Um,
delighted to. We've got some additional
yes.
slides about cool stuff about the office, so
We
Oh,
do. We did have a question that I kind of just saw as you went into the next slide, but I think you all kind of sort of addressed some of it, but I'll read the question to you.
sure.
You mentioned AI and false statements of law, not in the same sentence, but that is the danger of AI. It often paraphrases holdings of someone's opinion on the holding. The quotes it provides are often interpretations, not case quotes. How do you tell the client that what they got was not actual law, but AI just creatively generating something?
I don't know if I have a good answer for that. It's just it's not only a legal thing, it's just such a cultural tour de force now. Would do you have any thoughts on that, Karin? What's the best way that we can
You
for
know,
us to communicate with clients about this AI stuff?
there actually, a lot of wonderful resources have been written on good communication with clients. One of my favorites is BIFF for lawyers, BIF, brief, informative, friendly, and firm. It's by the lawyer and mediator Bill Eddy, who also wrote The Five Types of People Who Can Ruin Your Life, which is a great time saver for selecting clients. But I think in general, being brief, being clear, being friendly or compassionate, but not giving any wiggle room. I mean, yeah, it's awkward. It is going to be awkward, but that doesn't relieve us of our obligation to have to we have to wade in there like the soldiers run towards the sound of shooting. When there's a problem and it's something we need to deal with, we got to get in there.
All right, and we did get, I know we're right at time here, but one more quick question I got in a chat. Hypo, this person's requesting 30,000 flat fee or for divorce, all flat fee and lawyer rules followed correctly. Client fires firm before opposing party answers or ICMC happens. Firm offers 3,000 refund. Now a large fee dispute exists caused by lawyer. Lawyer Professional Responsibility Board will decide not to investigate a related ethics complaint as to refund only and say it is fee dispute 99% of the time, correct?
This is a question I don't know that I can answer as written, but I can offer a thought. One of the things we don't get into in investigating complaints is whether the lawyer needed to do the work that they did, whether the client received value for money. Those are things that are typically considered to be fee disputes. When a client is like, I don't think you deserve the whole 30, and the lawyer's like, well, I'm only going to give you 3, and you figure out where in the middle is the answer. That's not what we do. We investigate where it seems like a lawyer has charged money for work that they didn't do, which can include things like charging twice for the same thing, um, where there is some kind of, misleading or fraud or mishandling of fees. But in general, we're not going to, try to second chair whether or not the work that was done was worth the money in dispute. And that's kind of what fee disputes are about. I can't give an opinion kind of specifically, but in general, when it looks like it's a fight over, I shouldn't owe my lawyer this much money, that's a dispute we won't wade into. When it's I never agreed to this, or this was never explained to me, or he's charging me for something he didn't do and I can prove it, those are the things that we'll want to take a look at. I hope that helps.
All right, well, we're definitely over time, and I thank you both so much for coming today and sharing all this information and insight about ethical issues and how to avoid them. So, yep, we got a couple claps in the chat. Not a lot of people wanting to ask a lot of questions today, but I appreciate how you did the hypos. I thought that was very engaging. So, thank you so much for your time today, and hope everyone has a great day.
Thank
Thank
you.
you.
Take care.